Records Law. Sometimes people think, well, this Sunshine Law is so draconian. How about the Public Records Law? Well, it's even broader. It's broader than the Sunshine Law, because the Sunshine Law only applies to discussions between two or more board members on matters that may require foreseeable action by the board. The scope of the Public Records Act is much broader. Look at this definition. All papers, letters, maps, etc., 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 made or received pursuant to law or ordinance or in connection with the transaction of official business by any agency. So the Public Records Law guarantees a right of access to virtually all materials made or received by the government in the course of official business. It's so broad that we've even had how broad was it? We've even had litigation over whether or not a gun used in a shooting is a public record. Someone argued, well, the shooting occurred and law enforcement found a gun and brought it in as evidence, so law enforcement received a gun pursuant to its official duties, so therefore I can demand access to the gun under the Public Records Law. The court said, no, you cannot. The gun is not a public record. Why not? Because it cannot be copied. So every now and then, you do have this issue come up. Sometimes it's blood received by a law enforcement agency. There's been questions about whether or not it's subject to disclosure. It is not. It has to be something that can be used to record information and be copied. But as you can see, that includes virtually everything that the government uses to transact business, regardless of form. And obviously, as agencies found out to their horror a few years ago, it does include electronic transmissions. For many years, I used to have the opportunity to tell what I consider to be very funny stories about how agencies made all sorts of errors with regard to emails and sent them out to people they didn't mean to, or put things in them they didn't mean to, and then they were requested as public records. But now everybody knows. Email's a public record. The Attorney General also holding text messages are a public record. Facebook blogs are a public record. So virtually anything used to communicate information, public record, yes.
Now, what is the situation on private citizen? They're required to pay for public records. What about a public official? Is he required to pay, or is he exempt in order to do his job?
Well, you know, this issue comes up all the time, and sometimes I hear from both that public official and the agency. And what happens is the short answer is, yes, a public official can be required to pay for public records if it's the case of a county commissioner, then normally that decision is made by the rest of the county commission. By that I mean, what happens is this. Typically, county commissioners ask for public records from the county government. I mean, they do so because they say, well, I noticed that there's a big development for approval on our agenda, and I want to see more about it. I would like to make an appointment and go through the files. The county obviously makes arrangements for the county commissioner to come down there. This is done every day, and it's done at the state level as well. The decision makers want the staff to provide information. But what happens if you've got a dissident county commissioner that wants not only to look at that particular development file, but this new commissioner, just as an example, feels like the rest of the commission has just been rubber stamping development approvals, and he wants to go back and view 10 years worth. These are actually situations that occur. The county staff says, well, to do this is going to take us 2 weeks. I mean, we just don't have the time to do this, so what should we do about it? And the advice I give, clearly a county commissioner can make a public records request. I know of nothing in the Public Records Law, and our opinions have said there's nothing that exempt or mandates that this commissioner be exempted under the public records law from paying. But the county doesn't have to make him pay or her pay, but the person is not entitled, just like a member of the public is not entitled to get every single record that they want for free under the public records law. But what happens to me is, if the practice of the county commission has always been that county commissioners can get whatever information they need to make a decision free of charge, and you've got some indication that that practice is going to change, then to me the proper way to change that practice is for it to be brought to a vote by the county commission, because not just sort of changed by staff. I feel that sometimes that's not appropriate for staff to decide when to start charging essentially their bosses to provide fees under the public records law. So it's a terrible situation when that occurs, because from the commissioner's standpoint, they are trying to be better commissioners and represent their constituents. From the staff standpoint, they say we have to represent all of the people in the county, and we can't spend, what they'll tell me sometimes is days, constantly responding to one commissioner's request.
Now, what if it's data on the agenda? Say the issue goes back a year and a half, but it's something that's on the agenda or up for discussion, and you're wanting to make good, educated decisions and have the facts in front of you. So you're not just playing the staff's demands or staff's opinions or advice.
Yeah, I think
so
that's...
you read yourself. That would still be considered something you would need to pay for also?
Well, I would not consider it that way, but ultimately it's up to the Board of County Commissioners to be the managers of county government. So in my view, I can understand what that commissioner would be saying. I think that it's not up to the staff, this is just my own personal view, to make a value judgment as to when to charge the people. Everyone works for all the residents, but I mean to work for when county commissioners should be charged to get information they need to make decisions. In my opinion, it's something that first, if I were a commissioner, I'd take to the county attorney, and then my recommendation would be, if the policy is to change, and historically the policy always is for commissioners to get things that they need for the meeting at no cost, additional information, then that should be done by vote of the board.
Now,
so the parameters can be established.
If that's never been policy, though.
Well, it seems, you mean in your county, county commissioners have always had to pay?
No.
Then so the
Say
policy.
we just start that, and they've never paid.
Right. That's what I mean.
They've never paid, and all of a sudden, because maybe you're on a touchy subject that may get somebody fired.
But see, that's why, to me, that type of issue should be an agenda item. If any changes are to be made, it should be an agenda item. So those that feel that there should be unlimited access can be heard, so that the county staff can be heard, so members of the public can be heard, and the decision is made openly. But let me, after this session, I'll discuss it with you more, because I do get probably a question once a month about that, and if that's your situation, I've got some strategies that might be helpful. So moving on ahead, the courts, once something falls within the definition of public record, then the courts have said that if it is used to perpetuate, communicate, or formalize knowledge, that sets the threshold after which the record must be produced, provided applicable fees, if applicable, are paid, unless there's a statutory exemption. This is a principle I have fun with in my class at FSU, because I will say this over and over. I won't do this for you, but I say it over and over. We've got this 4-part test. if it's a public record, then the record must be disclosed unless there's a statutory exemption. There's no stupid exemption. There's no, I wish I hadn't done it exemption. There's no right of privacy exemption. There's nothing that would say that that record is not produced unless there's a legislative exemption. So sure enough, I would, at the end of the class, I'll give them a test. Or no, they establish quite quickly they're not going to be graded on it. So nobody gets up and leaves. But I'll say, I'm a police department. There's a closed case that's now a public record. Somebody wants a copy of it. Does the police, and I'll give the answers that the police department could use. Should the police department refuse to release it if the maker of the record says, I don't want it released? Is that a reason for the police department to refuse? They should say no. And I'll say, well, suppose to release the record would violate accepted police procedure. I would say always 10 people say, oh yeah, they shouldn't release it then. And I'll say, what did I just say? Unless there's a statutory exemption, they have to release it. And the students will say, well, yeah, but that violates accepted police procedure. And I'll say, well, then there'll be a record showing they violated accepted police procedure. Because under the law, they have to release a record. The fact that they shouldn't have made the record, perhaps, or it's even not in the public interest to release it. Not enough. Even if the other thing I'll sometimes say is, well, suppose the record is only a draft and the supervisor hasn't approved it. Can they refuse to release it then? No. And what do you think that the public wants to see the most? Drafts. Because drafts reflect something that the person didn't necessarily want to make public because it hasn't been finished. So almost always drafts are highly sought after. I would strongly encourage if, for example, people send you things marked draft and their intent is not to release it, that they be tactfully advised to stop doing that. It's a public record. Many times when people make a public records request, they already have the record. They're just making a public records request, first of all, to see whether or not you'll release it, or to see to get official confirmation that it exists. There's always people watching. There's always people that know, and people use the public records law then to get the evidence as to what they suspected occurred. I'm going to go up to these. This is the general standard that every records custodian, normally this is taken care of by your staff, provides access to public records. But for the records that you have not given to staff, who is the custodian of all those records? You. This is a serious responsibility to be the custodian of public record, which I must reiterate the point. I think if there's a phenomenon called multiple reiteration, I am making it at this point. If you make or receive public records on your personal computers or cell phones, the best course is not to do that, but if you receive them, send them to the government offices so they can be kept as a public record. I would strongly counsel you not to be the custodian of your own public records. It's a serious responsibility. There have been cases where records custodians who refuse to provide access to records have been prosecuted or have been sued. So don't keep them without sending them to the board office. Some of the methods that we use for a text message, hopefully you don't have many of those, take a picture of it, I guess with someone else's camera, somehow get it into the public domain, into the government offices, whether attaching it to your emails, or some agencies are already getting software that will enable any text messages to go immediately into a government server. But if you get them, make sure they're protected as public and preserved as public records. Like Herb already went through my whole outline, I think. And everybody answered this as fact, not the other word, that you don't have to show any special interest to get public records. There are laws prohibiting people from using public records for unlawful purposes. That's the sanction that the legislature has. If you get a public record and use it to defraud someone or harm them, that's a crime. But can the agency ask you why you want a public record? No. In other words, it's not the agency's business what people do with them. It's up to the state, though, can prosecute someone if it's going to be used illegally. And it's not illegal for an agency to notify an employee, for example, that there's been a public records request about them. Sometimes people do this in a case where an employee might have a protective order or something, restraint against violence. It's not unusual to notify them, but the employees do not approve public records requests, i.e. authorize release or delay them. All you can do is notify them so they are aware. Sometimes people ask for every single record that you have. Can you deny access? No. But they will have to pay for them in accordance with the fee schedule that Becky mentioned earlier. The one thing I would suggest that people keep in mind is that when people make these broad requests, they're not doing it just to victimize you. Many times, they really don't think you have as many as you do. Sometimes it's because they think you don't do that much. Oh, give them all the votes you took. Oh, you were never there. So they don't think it's very hard. So a tactful response by your county administrators or whoever is responding on your behalf is appropriate. No set time limit to produce public records like 24 hours or 10 days. The delay is the amount of time that it takes for you to go get them and delete anything that's exempt. So it's going to vary depending on how much is asked for. No, like Herb pointed out, no requirement that public records requests be made in writing. When records custodians do this, it is always caused to be written up in the newspaper as someone who doesn't know the public records law, because you can make a request in person or over the phone or in writing. Agency doesn't have to answer questions, just provide records. Sometimes people say, I want to know every single thing that you voted on in the last year. Even though that's all public information, you don't have to create a record that doesn't already exist or answer questions. That's a policy choice you make for your constituents. But the legal obligation is to provide records. That's why it's so important to make sure that any records that you have are in the custody of the county government so they can provide access to them. When you want to answer questions, that's when you're saying what you think as a public official is your responsibility. If you get a question like, when did you stop being a good county commissioner and become a bad one? If you want to answer that, fine. If you don't, fine. That's not a requirement under state law. Just because someone requests that something be held confidential is not a reason to refuse access to records. Does everyone on their county emails have that statement saying that, alert, alert, everything you send me is a public record, or something to that effect? That's the notification to members of the public that what they send you is something that they don't control disclosure. Once you get it, the law discloses, is what governs whether you disclose it. Your office or whoever responds on your behalf has to give a statutory exemption. This helps everyone to avoid the pitfall that my students sometimes make, which is to come up with some reason other than a statute for refusing disclosure. By law, you have to cite the statute that says that you cannot get this information. There's an exemption for Social Security numbers. If you have a record with a Social Security number, you redact it and cite that. Federal law is complex. Oh, this is Some records are confidential and cannot be disclosed under any circumstances. Others are merely exempt, and then the agency may have more discretion. Your lawyer, we all like to talk about that as from a legal standpoint. Federal law sometimes supersedes state law, but the federal disclosure provisions like the Freedom of Information Act don't control us here in Florida. The federal laws control federal records, generally not state law. Fees. Generally, you can't charge fees unless the legislature authorizes it, which they do. You can charge 15 cents a page or the actual cost of duplication for electronic records. And you can also pass along a special service charge which must be reasonable. Sometimes people get so aggravated with public records requests that they want to respond back, well, it'll cost $1 million if you have it. I mean, I've seen things like this. That is not a reasonable response. It's better to ensure that the staff, which I talk to a lot, they struggle with this. In my experience, the staff works very hard to make sure their charges are reasonable, but occasionally they do get frustrated and they want to charge some huge fees, which I'll say, well, how did you come up with that? I don't know. Joe gave it to me. And I'll say, well, how did Joe come up with it? I don't know. So the moral to that story is make sure that the fees are justified and the requester has a clear understanding of the tasks that are required to produce the records and the amount of time. Otherwise, like some of the 15 cents a page, you can require an advance deposit. That makes sense because otherwise, if you don't do that, if you produce thousands of pages of records and the person says, I never asked for this, then what's the agency supposed to do? No other, so it makes sense not to see this as a battle, in my opinion, as I think some of the questions have pointed out what happens when the staff, it's almost always the staff, but it can be the public official, places themselves in a position that's adverse to the public's interest in obtaining the records. It's always better to negotiate these, and to the extent there's a problem, feel free to consider our office in the Attorney General's office. We have a mediation program, and we're happy to help try to resolve these as a third party. Many times we can, and that means you don't have to incur any of these penalties, which I will gloss over. The biggest one being a civil lawsuit and more resources. If we had more time, I'd go over some of these. I think I have some questions in there. Too late, unless these are not, how can I possibly do these kinds of questions after fact versus crack? This is boring and difficult. So I'll just leave these with you because I know you've had a busy day. And feel free to call me if you have questions about what the answers are here or anything else in open government. It was such a pleasure to be here for your seminar, and I wish you a great week up here in Tallahassee. Thank you so much.